Hello and welcome to lecture number 8. As always, we'll start with a short revision of lecture 7, during which we talked about the second time about the other wards, persons under curatorship and persons under assistance. And I told you I was really diplomatic, so I told you that this is very interesting regarding, yes?
Will you talk about Gokong experience?
The Gokon experience. Oh, did I say that I will talk? Yes? Was I drunk last week or something? No. I'm joking, I don't drink anyway. So thank you very much. Let's do it in the middle of the lecture. Okay, thank you for reminding me. Thank you very much. But please note that you are not going to be asked about my Gokon during the final exams, okay? It's not. I told you that this is quite important. We talked about same-sex marriage. I told you what the issues regarding same-sex marriage in Japan are, and we said that there are some alternatives which are not exactly alternatives, but they function somehow like alternatives. We talked about the presumption of a child in wedlock. Also seems to be very interesting regarding your final exams. We said that there are some cases where the presumption does not apply. We also talked about de facto marriages. Please be careful, de facto marriages are not included in my material, but I talked to you about that issue. You do remember, don't you? Yes, it was the issue where you have a couple where a couple has been living together in de facto marriage even before the official marriage, and the child was born not after 200 days from the formation of marriage, maybe 100 days after, but 200 days after they started living together. So I told you that in that case, according to the Japanese Supreme Court, we also have a presumption. And because of the fact that the public servants working in the municipal halls, etc., cannot verify whether a couple has been living together before the marriage, in all cases where a child is born after the marriage, they apply this presumption. Okay? So that's how it is done in practice. We talked about two ways to refuse the parent and child, well, I would say the father and child relationship. The first was rebutting presumption of legitimacy, and please remember that in this case, the limitation for the action is 1 year. Whereas in the second action, in the case of action seeking a declaratory judgment on the non-existence of a natural parent and child relationship, there is no time limit. So that's why we could say in general that it's better for a child to be under presumption, in the meaning that after the lapse of 1 year, its status is finalized. Okay? Contrary to children for whom the presumption does not apply, to whom the presumption does not apply. We talked about affiliation and legitimation, and we talked about wills. So let's move to today's material. Lecture number 8, which means that I will see you 9, 10, 11, 12, 13, 14, 6 more times. I'm not good at counting. 9, 10, 11, 12, 13, 14. Yes, 6 times before the final exams. Okay? So, items that can be included in a will. We said that you can include something about affiliation, and as you remember, I told you that, well, in general, it's better not to do it that way because you might cause some trouble, because people will think that inheritance will be done without the child that you affiliate. We said that you can also designate a guardian. So let's say, for example, that you don't have a wife, so it's you and your child, father and a child, or maybe the wife and the child, and you want to designate the person who will take care of the child after your death. Otherwise, it will be decided by others. And we said that you can also designate the share in inheritance, which is the most important reason why you usually leave a will. Capacity to make a will, 15 years old. You all remember that by now. So if I ask you that in the final exams, it will not be a difficult question. And formalities for a will. So let's talk about the formalities. Do you have with you last week's material? If you don't, it's here. So let's talk about the formalities. Please have a look at last week's materials provisions. Article 960. Who would like to read the article? Is there anyone who would like to read this article for me, please? Okay, so. Kelsey. Yes, it took me a bit, but thank you very much. I'm really happy. So Kelsey, could you please read the provision? Thank you, Kelsey. You know, today it's really hot, so I can understand what's happening inside me. So thank you. Yes, could you please read the provision?
Article 960. No will shall take effect unless made in accordance with the formalities provided in this code.
Thank you. So, well, maybe today Matthew is not here. Oh, okay. So because he asked me about this issue. So if you check Article 960, it says that no will shall take effect unless made in accordance with the formalities provided in this code. Which means that if you want to personally leave a will in Japan, you need to check the provisions. We have two formalities. Ordinary formality in Japanese, 普通方式, and special formalities in Japanese, 特別方式. It's the Yoshida Ryosai. It's really interesting. Yeah. So we have three ordinary formalities: will by holograph document, will by notarized document, and will by sealed and notarized document. Please have a look at these provisions. If you check 968, will by holograph document, in Japanese it is Jihitsu Shōshoigon. So this is the one where you personally write a will. You take a piece of paper and you prepare the will on your own. If you have money, you can also make 969, will by notarized document where you need to pay some money to a public notary. And if you want to keep your will more secret, you can do 970 in Japanese Himitsu Shoshuihon, will by sealed and notarized document. Now, as you can see on this slide, I have written issues under will by holograph document. Why is that? Who would like to read Article 968? Only the first paragraph. Okay, let's start with Lily and then
To make a will by holograph document, the testator must write the entire text, the date, and his or her name in his or her own hand and affix his or her seal.
Thank you. So, this seems to be quite easy. You just have to write the entire text, the date, and your name in your own hand and affix your seal. Well, it seems to be quite easy, but there are some issues. For example, both of these have been argued in Japanese courts. Date. When you write your will, it feels a bit strange because you are providing for the time after your death. So sometimes you feel like you want to make it more lucky. So you write Kichijitsu in Japanese, which in English would be lucky or auspicious, etc. date, which means that you don't write the exact date. You write March on a very lucky day, for example. And according to Japanese courts, this makes the will invalid. So, you can see that a very small detail can make the will invalid. Another case which was judged by the Japanese Supreme Court last year, a very recent case, was a case where a person wrote the whole will, and at the end, instead of, as Article 968 paragraph 1 requires, affixing his seal, he wrote a stamp-like signature, in Japanese kao. What's that? Here you can see some stamp-like, it's not a stamp, it's a signature, but it looks like a stamp. You can see some very famous ones, Minamoto Yoshitsune, for example, Toyotomi Hideyoshi, etc. So, this has been existing in Japan from the past. So let's say that when I write my will, I don't fix my seal, but I write something like this at the end to make it seem a bit more cute. So, if I do this according to a decision of the Japanese Supreme Court last year, very new, my will is invalid because this is not my seal. So you can see that if you want to avoid paying money, then you also take a risk. So usually we advise people to do either 969 or 970. Now, last night I was reading this by chance. Okay, oh yes, I need to translate it in English. In English it would be the woman who was a professional second wife. Is that a good translation? Okay, yeah. So it has to do with a woman who gets married with old people and asks them to write a will, leaving everything to her, and then kills them, or yes, she kills them. Yes. So she got married to 6 or 7 people. The reason why I read it was because yesterday the first volume was free, so I didn't have to pay. I had to pay for the second volume, which is why I did not read it, but it seemed to be very interesting. So why am I showing you this? Because wills can create also big issues. On the one hand, you feel sure, you feel certain that you're certain that your property will be divided according to your the way you want to be done. On the other hand, if you leave all your property to a person, there is chance that that person might want you to die earlier because he or she wants to receive the property earlier. So that's why maybe a sealed and notarized document, in Japanese, himitsu shōshō igon, is a good choice because it is kept as a secret, etc. So you need to understand that wills have both advantages and disadvantages. I had a friend who had this issue. His father was 80 years old, he got remarried, and he left all his property to his second wife because she told him that, you know, your children don't like me. If you die, they're gonna behave badly to me. So I would feel more sure if you could leave me all your property, etc. And he did that, and so she received 17 million yen and she escaped. And the 5 children received nothing. So it happens, and it usually happens with men. Okay, so we need to accept that women are maybe smarter in these cases. Anyway, okay, so in many cases, but anyway. So today we are going to talk about contracts. Next week we are going to talk about contracts and consumer protection. So, today's lecture has to do with next week's lecture. What we will learn today will be used also next week. Okay, so today's lecture is combined with next week's lecture. In Japan, we don't need to have a document in order to have a contract. We don't need to have a document. So if I tell you I will sell you my watch for 10 yen, and if Chisaki says, yes, I buy it for my boyfriend, then I cannot tell her, you know, I changed my mind. You know, this is a watch of 20,000 yen, so I'm not going to sell it to you for 10 yen. No, we have a contract actually. There are some exceptions, but if I say I sell it to you, and you say I buy it, and we also agree on the price, there's a contract. Offer and acceptance. That is what we need. What does that mean? I offer, which means I say, you know, I sell my watch for X yen, and you accept. You say, I buy your watch for X yen. Offer and acceptance. 2, manifestations of intention, ishihyoji. You express your intention to sell, and the other person expresses his or her intention to buy. 2 manifestations of intention. There are some exceptions where we need a written contract. For example, in most cases of consumer contracts that we will see next week, because consumers are in a weaker position than the companies, in most cases, the law says you need to give the consumer a document, a contract document, so that he can read and he can understand better. Another exception has to do with companies. I was writing a comment a month ago about this case. This is a real case. A very famous Japanese company, B, was planning to cooperate with a Chinese company in China to create a merged company, so to cooperate, create a company in China and create also a factory in China which will produce liquid for batteries. As you know, batteries use some liquid inside, so they were planning to do this. In order to have a factory, you need to have someone to build it for you. So, B was thinking of assigning the construction to an also famous Japanese company, A. I'm not giving you the names, but they're both very famous companies. So, A and B were negotiating, and we are talking about amounts more than 100 million yen. Okay? So, they were negotiating, and B almost assigned the construction, said that, okay, we agree on this price, etc. In the meanwhile, A was going to China to employ some employees, started paying some money, etc. But at some point, C said, you know what, A is quite expensive, so I don't agree. We're not going to use A. Now, A had already paid a lot of money to employees, etc., etc. Also had paid a lot of money for traveling to China, etc. So A asked for compensation against B, damages, songai baishu. The first issue was, do we have a contract between A and B? If you check the emails, they were saying, yes, please start with the construction. So I would say, oh yes, there's a contract. They agreed on the price, and they also said, please start the construction. The court said, no, there is no contract. Why? Because these are big companies. And usually in the case of big companies, you have a contract, a paper. You don't do it orally or by emails. So please understand that although according to the provisions of the Civil Code, you don't need a contract, in practice, there are mainly two exceptions. The first exception is a case where the law says, no, you need to have a paper. The second case is a case, for example, of the large companies, where the courts have said in many decisions that, no, in cases of large companies, you usually have a paper. So if you don't have a signed contract paper, there is still no contract. It's still during the negotiation phase. You also need to be careful. Now you have understood that sometimes whether we have a contract or not is very important. And you need to know that the evidence for the formation of contract in general is not restricted to documents. You can also use emails. For example, in my previous example, between me and Chisaki, Chisaki could bring 3 students as to testify, to say that yes, he said that he's selling his watch for 10 yen, and she said that she's buying it. If we went to court, you could also do that. Okay? So it's not only documents, it's not only emails. You can use everything as an evidence to show that the contract has been concluded. Any questions up here? Yes, Calvin.
For large companies, what about small companies?
That's a very good question. Indeed, usually these decisions have to do with large companies. So I guess it will be a case-by-case decision. You have to see the amount, you have to see the whole procedure, etc. So, answering your question, I would say that in principle, no. Yes, so in principle, when we have large companies, the judges tend to say that we need a document. If we have medium or small companies, it maybe depends on the case. Any other questions? Okay, so let's now move to something which is also really interesting. Takeyoshi Kawashima and Takashi Uchida are two famous Japanese scholars. Takashi Uchida is still alive. Takeyoshi Kawashima has passed away. He was a very famous scholar in the past. They both say almost the same thing regarding contracts in Japan, which is quite interesting. They say that, in Japan, a contract is regulated more by the social relations than the formal agreement. Which means that you don't have this. In Japan, according to their, you don't have this in your slides. According to their understanding, the contracts are not so clear. Why is that? Because people do not care about the contract. They think that if something goes wrong, they will arrange it depending on their goodwill and friendship. According to this understanding, people in Japan do not think that they are bound by the contract. So even if we have a contract, even there is a provision, they will say, yes, okay, the contract says so, but maybe we could, etc. So according to this understanding, people in Japan think that you can change the content of a contract. You can say, yes, we agreed that, but etc. According again to this understanding, in Western countries, for example in the United States, the contracts are more detailed, clear, and also objective, which means that you can understand the content only by looking at it. People in Western countries perform the contract without asking for changes. They don't say, yes, we have agreed this, but I think it would be better if. This understanding has been strongly criticized by many people. Many people say, no, this is not true. Contracts are the same in Japan and in Western countries. So, just to give you some small examples, some lawyers who support this understanding say that, yes, if you see Japanese companies, when they conclude a contract with a foreign company for imports and exports, they say, we will have a very good cooperation. So if the lawyer says, we should put some penalties if they're late, they're like, no penalties, this will harm our relation. No, we trust you. Are you going to be late in deliveries? No, of course not. Okay, thank you. See, he says no, so everything is gonna be fine. If you're a lawyer for a foreign company, your customer will ask you, we know that they are a big Japanese company, but what happens if they're late? Oh, penalties. Okay, yes, good. For example, okay? So I have also seen this. But some people say that this has changed. This is very interesting if you think about it, especially if you have lived in both countries. A very good way to think about it is not contracts, or it's something like a contract, marriage. So, if you go to the States, you will see that famous actors and actresses, Hollywood, when they get married, they do a pre-marriage contract. They agree, if in the future we get divorced, you keep this and I keep this. I have a small seminar. I asked my students, would you do that? Their answer was no. Why is that? Well, because she would feel sad. We are going to get married. And I would tell her, honey, maybe in the future we will get divorced. Maybe. So in that case, maybe you should keep this and I should keep that. So usually the answer of Japanese students is no, I would not do that. I would trust her. So my answer is, you need to go to a court. You need to go, if you have a day free, just go to Kyoto District Court, to the section where they're doing divorces. and you will see how it's not darling and honey anymore. Okay, this stupid guy, please do not use that word in the court. Okay, so this guy here, something like that. Okay, and many other words which I cannot use during this lecture. So it's the same way of thinking. It has to do with, do you prefer to arrange things when the relation is still good? If yes, then your contract will be detailed because you still have a good relation, which means that you can agree. You can say, no offense, but if you're late more than 1 month, maybe we should ask you for a penalty. Okay? The same happens with marriage. When you're in love and you call each other honey and darling, maybe it's better to say, honey, come here, let's agree about our divorce. Because in both cases, when things go wrong, you cannot even negotiate. And if you don't trust me, if you don't believe me, please go to the courts. And you will see how people are unable to communicate after or during the divorce procedure. But anyway, this is quite interesting. Oh yes, any questions after this one? Oh yeah, so would I do that? Of course not. I would not want to hurt her. So I wouldn't do a pre-marriage contract. You need to be romantic. So I agree that it's quite difficult to do it. But in general, I would say yes, you should do it. So we will talk about defective manifestations of intention. In Japanese, kashi aru ishihyoji. In the Civil Code, we have 5 categories. The Japanese names are quite difficult, as you can see. Concealment of true intention. In Japanese, shinri ryuho. And you see that the kanji is quite difficult. It's not the ordinary one. Fictitious manifestation of intention. In Japanese, kyoihyoji. Mistake in Japanese, sakugo. Fraud in Japanese, saji, and duress in Japanese, kyohaku. Please be careful, this kyohaku, the kanji, is different from the kanji in the penal code, keiho. There you have the odosu one, so this is for the civil cases. We are not going to talk about all of them, because we don't have enough time. We will only talk about fraud and duress, because they have to do with next week's lecture, which is combined to today's lecture. In general, you need to know that in 1, 2, and 5, in 1, 2, and 5, the person who makes a manifestation of intention, the person who says, I will buy, or I will sell, or I will do something, is aware that his manifestation of intention is defective. He knows it. In cases 3 and 4, he or she is unaware, so he or she does not know that his or her manifestation of intention is defective. So, let's start with fraud. Article 96 of the Japanese Civil Code will be used for both fraud and duress. So, I think it was Isagi's turn. Could you please read Article 96?
Manifestation of intention which is induced by any fraud or duress may be received. In cases any third party commits any fraud, including any person to make a manifestation of intention to the other party, such manifestation of intention may be rescinded only if the other party knew such fact. The rescission of the manifestation of intention induced by the fraud pursuant to the provision of the preceding 2 paragraphs may not be asserted against a third party without knowledge.
Thank you. So, Saki, you can see that the provision is quite long, but it does not say what a fraud is. Why? Because as you remember, the Japanese civil code is very old. When it was created, people did not care about us ordinary people. They were like, no, it is enough if lawyers understand the content and lawyers know what a fraud is, so you don't write it. But 2 days ago, I think, the reform of the civil code was completed. Maybe you saw it on the news, which means that maybe the new civil code will be more easy for us to understand. Anyway, it will be in effect after 3 years. So the first year students are, maybe you have to care about both civil codes. If you're gonna sit for bar exams or etc. in the future. So, what's a fraud? Usually, you have 3 steps. The first step is that you deceive somebody. So you tell somebody, for example, a lie. The second step is that by deceiving him, you cause him a mistake, in Japanese, sakugo, which means that he misunderstands something. And the third step is that he makes a manifestation of intention. He says, for example, yes, I buy, or yes, I sell. Why? Because he is deceived. Because there is a mistake in him. A typical case of, because this lecture's title is Law and Culture in Japan, so we have to talk about the Japanese culture too. Typical case in Japan was during the 1960s and to 80s, the so-called wasteland sale fraud, in Japanese, Kenya Shoho, where people would sell pieces of land which are in very remote areas, which were worth almost nothing, for a very high price, by saying, you know, the Shinkansen will pass, there will be a Shinkansen station here, so the prices will rise in the future, etc. And there were many people who were deceived and bought pieces of land worth nothing because of such frauds. So you can see that we even have a special name for this type of fraud in Japanese. So, what do we need to have in order to say that there is a fraud? Okay, so you asked me to talk about my Gokon experience. Maybe we should do it now before I forget. So as I told you, I only went, do the foreign students know what the Gokon is? How? Chisaki, you have the microphone. How would you explain a Gokon in English? It's very hard. I leave it to you.
It's basically like a row of guys on one side and a row of girls on the other side, and then they both talk and then see if they're like compatible with each other, and in the end they decide if they want to date them or not.
Wow, that was so professional explanation. Thank you, Chisaki. You reached the maximum by explaining the Gokon today. Congratulations. So yes, that's, if you have any questions, you can ask Chisaki, not me, okay? Because I've only participated once. I have a friend, he's 50-something years old, and he is a president of a company which is a company affiliated to a large TV company. One day he told me, it was 7 years ago, okay, 7 years ago. He told me, you're not married. I said, yes, I'm not married. So he told me, you're a foreigner. I was like, yes, I'm a foreigner. He told me, I have 3 employees, ladies, in their 30s. I was 30 then. They were also 30-something. Who would like to get married to a foreigner? So I was like, okay, so I'm not a foreigner. Oh, I am a foreigner. Okay, yes. So he told me, but you know, they're 3, you're 1. So could you bring 2 other guys? The first guy I thought about is an American lawyer of Greek origin who lives in Japan. And he works in Tokyo in one of the largest Japanese companies, law firms. So I sent him an email. I asked him, you know, I'm arranging, not I, well, a friend of mine is arranging a GoCon. Would you like to participate? And I should stop it there because his answer was, of course, I'm a GoCon king. So, an advice from me, if somebody tells you that he is a GoCon king, don't call him, okay? Usually these people are dangerous. Yes, because the GoCon was not good, not because of the ladies, but because of him. So that's what I'm going to explain to you. And I told him, can you call also somebody else? He told me, oh, there is a lawyer from Australia. He came to our firm a month ago. So he's looking for a girlfriend, so maybe we should be there. So, me, a Greek origin American lawyer working in Japan, and an Australian origin lawyer working in Japan, with 3 very beautiful and nice ladies working in a company affiliated to a TV company. It was the day when you start drinking the Beaujolais Nouveau, the wine. You know, there is a certain day when you can start drinking it. So when he arrived, the GoCon king, he was already drunk. He told me, you know, I went to have some Beaujolais Nouveau, so you could smell it from his mouth. So I was really worried, and yes, it happened. So one of the ladies was wearing a nice dress, so he was like, is that a swimsuit? It looks like a swimsuit. I was like, oh my God, stop, oh my God, stop. But the biggest mistake was after that. There was a lady with very big eyes, beautiful lady, but he was drunk. So he told her, your eyes are so big, you look like E.T. And he did not stop there. He was looking at her, he was doing bzz, bzz. So, yes, so that's why I have never participated again in a GoCon, because the ladies usually are beautiful, etc., but the guys are very big issue. And oh yes, let me give you the worst part of this story. His name is also Antonios. You know, it's so awful having the same name, being both big. They will think that we are all like that. We're not, okay? So, do you have any questions regarding my GoCon experience? No, you don't, okay. So, yes, so you're young, I think you should go to GoCons, okay? But please be careful whom you will take with you. Do not take anyone who says that he is a GoCon king. Do not take anyone who says she is a GoCon queen, okay? You avoid those people. Okay, so let's have a 5 minutes break, and if you have any other questions, feel free to ask.
Are you okay?
You can see their duties. You can either
Yeah, literally. Oh yeah, dude, that has stop. It's too much. I can't hear you.
You complain like that 5 hours company. I just enjoy the first half because like what company.
There are enough ways for Why? Because they wanna rest.
Oh, I know. Find the
Okay, so let's continue with the second part of our lecture today. So, we are talking about fraud. We are saying that fraud also existed as a social issue in Japan in the 60s, 70s, and 80s regarding wasteland sale fraud. So maybe you could, when after the lecture, especially the foreign students, maybe you could think, oh, is there anything similar in my country? Or if you have lived abroad, you could think, was there anything similar in my country, etc. Now, please be careful. There are 4 requirements to be fulfilled in order to say, yes, we have a fraud. The first is that we need to have an act of deception. The second is that we need to have a manifestation of intention which was made due to a mistake. The third is that there needs to be causal relationship, in Japanese, inga kanke, between 1 and 2. And the fourth is that there needs to be intention for fraud. Why am I explaining this? Because, as you remember, today's lecture is connected to next week's lecture. Next week, we're going to see that the consumer law provides for a better protection for consumers. Let's see why. Act of deception. So, if the salesperson, in this case, lies to the customer, says that there's gonna be, so the Shinkansen line will pass this area, so the prices will rise, you have an act of deception. If the buyer misunderstands, so there is a mistake created, he thinks that, oh, this piece of land is going to have a higher price in the future, and he says, I buy it. You have number 2. You have a manifestation of intention, I buy it, because of a mistake. If this mistake and manifestation of intention were created by the act of deception, so let's say that this person would not buy this piece of land because it's in a very remote area. He's not interested. He bought it because he believed the lies, etc. You have number 3, causal relationship. But usually you don't have number 4, or you cannot prove number 4. Why is that? Number 4 is intention for fraud. In Japanese, 詐欺の恋. Not 恋する fortune cookie, not the koi, the other koi, koi kasu koi. Okay. So, this intention, according to the Japanese courts, needs to be a double intention. Intention to deceive and intention to induce a manifestation of intention. What's that? So, the first part is that you need to have the intention to deceive somebody. So please be careful. If you have a friend who often lies to you as a joke, then you have the first part, but you don't have the second part. So you cannot say that your contract is not valid. Question to you, double marks. Why is it difficult to prove that you have this double intention? Or at least which part do you think is difficult to prove? I know that you're all nice people, so you have to try as people who are not nice. What would they say during a trial? It has to do with evidence, with proof. So let me remind you that he, the buyer, needs to prove all these 4 requirements in order to say, I rescind the contract, give me my money back. So what is difficult with the double intention? I will give you triple marks. It's like an auction. Okay, yes, so Yosuke, could you please give him the microphone?
I think intention to deceive is hard to prove.
Excellent. Why? Excellent. That's correct. Why?
Because the person who deceives says, I didn't have any intention to deceive.
Excellent. So, you're very close, yes?
So, no one can prove.
Thank you very much. Excellent. So, congratulations. You've got triple marks, Yosuke. So, he is right. The part which is difficult to prove is the intention to deceive. Why is that? Because, let's say that in the future, you work as employees in a company. And somebody tells you, oh, you know, in this area, the Shinkansen is going to pass that area, so the price is going to rise. You believe him. So you go to people and you tell them, oh, you know, I've got this information. You don't have the intention to deceive because you believe what you're saying. So the same could happen in many cases of fraud. The salesperson believes what he's saying. He believes that if you drink that tea, you will become very beautiful in 2 days, for example. He believes that this has effect. He believes. So if you have employees who believe what they're saying, they don't have the intention to deceive you. Which means that if I believe that if you put this watch on your arm, you will pass this lecture, then if I tell you, you know, if you put this, you're going to pass the exams, and if I sell it to you, I don't have the intention to deceive you, which is a chaos, as you can understand. It's very hard to prove that, no, he had the intention to deceive. The other issues are quite easy, but the intention to deceive is quite hard. So, as you can easily guess, it's really difficult to prove that there has been fraud. It's really difficult to ask for a rescission of the contract it's really difficult to ask for your money back. But don't worry, next week we're gonna talk about consumer protection, where we have special provisions which protect us better. Any questions regarding this? No. So, let's move to duress. In Japanese, kyohaku with the kyo tsuyoi kanji, not the odosu kanji, for civil law procedures. Again, this provision, which Chisaki read, Article 96, does not say what duress is. Why? Deja vu. Because the people who created the civil code did not care about ordinary people. They thought that the civil code will be used by lawyers and judges, and lawyers and judges know what duress is, so you don't need to explain it inside the law. Duress is causing fear to another person by indicating malice to him or her and inducing him or her to make a manifestation of intention due to such fear. This lecture's title is Law and Culture in Japan. We need to refer also to the culture. So, in Japan, especially around the 1950s, you had very often the so-called oshiuri, in English, aggressive or high-pressure selling. A guy like this would come to your house. You can see that Japanese traditional houses are ideal for them because they can sit at the entrance, so they don't have to be standing. Okay? You have the genkan. It's a bit like a chair, so they can sit there, which means that they can easily talk to you for hours. Otherwise, if they're standing, they have to leave. So the traditional Japanese architecture is quite ideal for this high-pressure selling. In the 1950s, this was a social issue in Japan because many people would come to your house and would tell you, you know, I left the prison, so I was released from the prison yesterday, which means that he's a dangerous person, okay? And he or she would tell you, usually it's he would tell you, I'm trying to do a new start. That's why I'm selling you this piece of rope for 9,000 yen. You would say, wow, that's so expensive. And he would say, you know, I'm trying to make a new start, so you understand that I need money. And I just left prison. So if you live alone, you would be like, okay. And sometimes you would tell him, you know, I'm not interested. So he would like, I told you that I left prison yesterday, you know. And people who leave prison often go back to prison. So you understand why, don't you, etc. So you would be like, okay, bye. You can see the same thing in many Japanese animations. This is from Doraemon. And he's actually selling a piece of rope. So this is what was actually happening that time. They would sell pieces of rope, which you don't need anyway, for a high price, etc. And they would insist for a long time. So you would feel like this. You would feel, oh, just go away. But you could not say it. Of course, if you were him, you would say, but we are not him, so we cannot say it. So, the issue is, okay, I bought the piece of rope for 9,000 yen, but of course I don't need it, and of course it's very expensive. I would like to rescind and take my money back. Can I do it? According to Article 96, yes, you can. Again, requirements. Two requirements. Manifestation of intention induced by duress and illegality of such duress. Now, please be careful. In both cases, duress and fraud, you can see that, let's say that, okay, let's use it the other way around. You are a female student and you're living alone. Somebody knocks on your door, you open, and it's somebody who looks like Mokomichi. he's very handsome, really handsome. So you're like, oh my God, he's really a god, he's so handsome. So he tells you, you know, if you drink this water, you will lose 10 kilos in a day. You're like, okay, that's a fraud. But he's so handsome. So how much is that? 9,000. You're handsome, I wanna buy it. Although I understand that you're telling me a lie. You cannot rescind. Why is that? You don't have number 2. Your manifestation of intention was not due to a mistake. It was due to the fact that he's handsome. The same in this case. Okay, they're not both so handsome, so... okay, let's say no, he's not so... okay, let's do it the other way around. You are a male student, you live alone, somebody knocks on your door, and it's a lady who looks like Aya Ueto, for example. So you're like, oh my God, she's so beautiful. And she tells you, you know, I left prison yesterday. You're like, welcome to my house. Would you like to have some coffee with me? So you're not afraid. She's telling you, you know, if you don't buy it, I'm gonna punch you. And you're like, oh yes, please do that. Please punch me. So in that case, there is no number 1. So you need to be careful regarding these 2 issues. Another issue, duress needs to be illegal. Please be careful. This is a case which actually happened, and it went to the Japanese courts. There was a president of a company. He had an employee who took some money away from the company. The president found out about that, so he told his employee, you're going to write a piece of paper and sign it. And you're going to write that you're going to give me my money back with interest. Otherwise, I'm going to file a complaint to the police. He said, oh, that's duress. You're threatening me. So the Japanese court said, no, duress needs to be something illegal. In this case, the president has the right to file a complaint. And what he is asking the employee to do is also legal. So this is not duress. If he signed the paper and promised to give the money back, that contract is valid. Any questions regarding this? Okay, so let's move to the last part. 2 more slides. Maybe you realize that after this point, we were talking about the formation of the contract. It was the part where you're negotiating, where you sign, etc. Now we move to the content. So this is after signing the contract. You have already signed. The signing procedure was okay. Nobody deceived you. Nobody forced you to sign. But you have a look at the contract, and it has some strange provisions. Next week, we're going to talk about consumer protection. And you will see many interesting cases, many recent cases. Let's see what happened before consumer law came into effect. Who would like to read Article 90 of the Japanese Civil Code? Yes, so Yuki.
Article 90. A juristic act with any purpose which is against public policy is void.
Thank you. So, Yuki, you can see that if A and B, they sign a contract, and they want to sign the contract, there is no fraud, there is no duress, but there is a provision. So the content of the contract is a bit strange. We can use Article 90. We can say, you know, this contract has a purpose which is against public policy. It is void, so give me my money back and take your thing back, for example. As you can understand, public policy is difficult to define. What is public policy? Public policy changes depending on when, where, etc. Let me give you some examples of contracts, real contracts in Japan, which have been declared void as being against public policy. A contract between a married man and a woman who knows that he is married, under which he will pay her living expenses until they can get married. So you can see it is a sort of a mistress contract, but it has the characteristic that he agreed to pay until they can get married. So, as you can easily understand, at some point he got bored. He was like, why do I have to pay her so much money for such a long time? He wanted to stop paying, but they had this contract. So, he said that, this contract is against public policy. And the court said yes. Question to you, double marks. Why is it against public policy? Which part of it is against? Yes, ma'am? Did you give her?
Is it moral?
Meaning?
Moral means something the people in the society believe that it is proper to do.
Okay, so which part would you say here is immoral? Which is the same as being against public policy?
He is married
Okay.
already. Right?
Well, if you watch the movies, etc., you will find many rich men, it's usually men again, or stupid, who pay money to women to have an affair with them, and that's quite legal. Because you agree that I will look after you, and she says, okay, look after me, pay me some money every month. If you sign a contract, you're very close. There is a specific part which is special in this case.
So the part is like the immoral part.
Yes.
Is that he will
Yes.
pay her living expenses?
No,
No.
I think that's okay. And it actually exists, as you know. So which part makes it immoral? Which part?
Until they can get married?
Oh, she's also raising her hand. Could you pass the microphone to her?
Is it that the woman knows he's already married?
Okay, you're very close. Actually, Juan said the right answer. What's your name?
Chloe.
Okay. Oh, Chloe, you look different again. You're wearing the hat this time. Sorry. No, we just talked. I'm sorry. Okay. So Chloe and Juan are both correct. The part which is immoral is that, you're very close. Chisaki, what were you saying? You were saying something. No. The part which is immoral is that he has to pay until they can get married. Why is this again public policy? Because if he wants to stop paying, he needs to take a divorce and he needs to marry her, which are things that you cannot force. So you can agree that I will pay you your living expenses as long as we have an affair, etc. But you can understand that if the court said this contract is valid, the only way for him to stop paying would be getting a divorce and getting married. There's no other way, according to this contract. And both divorce and marriage are things that you cannot enforce. So you can see that that element here is against public policy. Okay, it's not paying the money. It's the part which says you can only stop if we get married. Okay, which means that if he wants to stop paying, he needs to take a divorce and get married. Otherwise, even if he takes a divorce, he still has to pay because they are not married. Yes, you have a question? Yes.
So if this contract doesn't have the part where it says that until they get married, so it's not void, right?
That's a very good question. So, okay, so you are grown-up adults. I will talk to you about some details. If it has to do with a sexual relation, then it is void. Because in Japan, prostitution contracts, which mean a contract under which you pay money to have sex, are void because they're against public policy. Prostitution is prohibited. So nobody can say, I paid her or I paid him money and judge, he didn't have sex with me, so please enforce him or her to do it, because the contract is void. So that means that if you agree to pay money as a price for having a sexual relation, a long-term sexual relation, then it might be void because it has to do with the sexual relation. But if you agree to pay because I love her and I want to take care of her, then it's okay. So these are some details which you need to take into consideration, okay? But you need to know that in Japan, prostitution is prohibited, which means that contracts paying for sex are also void, which means that also here you cannot have it because it will be judged as having an element of prostitution inside. So if it's just a contract that, yes, I like her, I'm gonna take care of her, that's okay. Okay? So it's what? Okay? Okay. Second case, sale contract of food containing toxic substances, knowingly in breach of the Food Sanitation Act. Now, you can understand that it's illegal to sell food which contains toxic substances in breach of the Food Sanitation Act, but normally this contract would not be void. It would be a contract which had a problematic performance. So he gave something which he should not give. But in order to stop such contracts, the court said no, the contract itself is void, so you need to give the money back, etc. And this is maybe a very interesting case, quite Japanese. In Japan, lawyers, so if in the future you want to become lawyers, are protected by the Practicing Attorney Act, which says that people who are not lawyers cannot act as lawyers, cannot do things that are lawyer-like. So, for example, even if you are an excellent student in my lecture and you have understood a lot of things about marriage, affiliation, etc., you cannot say to a friend of yours, I can give you some advice because I have learned about that, 5,000. It would be against this Practicing Attorney Act. Of course, there are some requirements, okay? Now, in this case, in Japan, as I told you, there are some professions which are similar to the lawyer's profession, like the judicial scriveners, shihoshoshi, etc. There is a very long battle between lawyers and such professions because lawyers want to protect their field of activity and the other professions are trying to do something which is similar to the lawyer's activity even though they don't have a lawyer's license. So, according to the Japanese court, these contracts, that means contracts with a person who is not a lawyer but you assign him to do something which is lawyer-like, are void, which means that there is no contract between you and that person. So you can see that in these cases, the courts are doing this in order to stop such practices. Any questions regarding this part?
But,
Yes, Calvin.
What we do is
Oh, the microphone, please. Yes.
it is not binding, but what the person, what they do is not illegal. I mean, they can do that if they have some kind of trust or third party that enforce it, like some kind of escrow account or something.
Okay, which one are you?
The lawyer in breach of practicing attorney act. Say that I read a contract for you. You are not a lawyer, but you read a contract for me, and then I use the contract. What we do is not illegal, right? It's just that you cannot ask me for payment or something.
Okay, so according to the Practicing Attorney Act, the person who is assigned to do, who so accepts to do such things, is punished, and also your contract, as you said, is void. So it's both. Okay. Yes, it's a good question. Any other questions? So, this provision is quite important because, for example, drugs. Okay, you pay somebody money to bring drugs from abroad, which is illegal. If it is just illegal, then maybe you will get caught. But if the contract is valid, if you bring the drugs, you can ask him, pay me the money. And if he does not, you can sue him. You can go to the court and say, Judge, look, here's the drugs, see, fresh. I just brought it from abroad. He's not paying me. Please tell him to pay me. And the judge would say, oh, let me see the drug. Okay, it's really good drug, so yes, pay him. He brought you a good cocaine from abroad. So you can say that it's, because it has to do with your question too. The penalties, the penal punishments are something, and we also have something else which is called the lack of effectiveness of the contract. You need to have both. Otherwise, you might get caught, but you can still ask for money based on your contract, okay, if it's separate. Okay? The same goes with a contract where somebody agrees to kill somebody. Okay, you kill a person, and if your contract is valid, you have the right to sue him to pay you money. Okay, but you can understand that it's a bit strange. Okay? You cannot say to the judge, you see, I kill him, give me my money, etc. So you need to understand that this is something additional to the penal punishments. And finally, we also have the principle of good faith. Who would like to read Article 1, Paragraph 2 of the Civil Code? Yes, Yuki?
Article 1, 2, and the exercise of rights and the performance of duties must be done in good faith.
Thank you. So, what is good faith? Please underline last step. Please underline this part which says last step. So, you have a contract which was not concluded due to fraud, which was not concluded due to duress, the procedure was fine. There is a provision in the contract which you find to be quite burdensome, so it puts a burden on you. You check with your lawyer, and he says, you know, yes, it's a bit heavy on you, but it's not against public policy, because public policy is something really heavy. So it's legal, but you're right, it's too much to ask you to do that. In that case, you use good faith as a last step, as a final step. And you say, yes, we have agreed to do this. It is not illegal, so you have the right to ask me to do this. But under these specific circumstances, it's too much. I will not give you examples today. I will give you some examples next week, because as you remember, next week, we're going to see all of these again according to the new legislation, consumer protection legislation. So you will see how easier it is nowadays to deal with such issues. So, if you have any questions, feel free to ask me. Thank you very much and see you next week.